rise. The Court of Appeals Division 1 is now in session.
Thank you all. Please be seated. Good morning. We're here today for oral argument in our case Whitestar Solutions LLC et al. Versus Medmen Enterprises Inc. Our case number 1 CA-CV22-0738. Each of you have 20 minutes for oral argument. You will be expected to, if you want to reserve some time for rebuttal, you have to keep track of that yourself. We have conferenced this case, we've reviewed the record, and we're familiar with your briefs. Please keep that in mind while you're doing oral argument. We will be audio and video taping these arguments for later presentation. I think they're live streamed actually, so people can watch them live, but we'll also be playing them on YouTube. So when you get up, please introduce yourself and who you represent so that the millions of people that will watch it later can know who's who. With that, I'll turn it over to you.
Good morning, Honors. May it please the Court, Louis Lopez of Fenimore Craig on behalf of the appellant, Whitestar Solutions, LLC. By way of roadmap, I'm going to start with the restriction that was in place, why Rule 904 did not require it, and then subsequently the harm and damages that Whitestar Solution suffered. Regarding the restriction in place, I'd like specifically for your honors to look at page 13, paragraph 3 of Medmen's brief. Because at that specific brief point, they state that the representative letters provided in accordance with Rule 904, which Whitestar knew prior to closing and had to comply with, that the shares would need to be returned if they were not eminently sold. The term need is mandatory. Need is something
but
that
didn't you know that before you guys signed the contract? I thought there were emails there where it's explained to you that there's going to be a legend, that's because if you want to sell them in the U.S. Stock Exchange, all that you were going to have to lift the legend. And isn't there a responsive email from one of your representatives that says, okay, and the Medmen says, here's a broker you can use, this is an easy task. I mean, this was before the contract was signed. So how do you get around that?
There's two components. What Your Honor is referring is to the initial legend affixed to the securities. There's no dispute that we understood that there was going to be a legend.
Okay.
The legend is then removed.
Right.
Once the legend is removed, the restriction is we were required to sell the shares within a defined period of time. That is the restriction that we are referring to.
Right, but that didn't come from Medmen. And it didn't come from, that was an after the fact where someone else, some third party advised you that you were going to have to put it back on in 30 days. Is that correct?
That is incorrect, Your Honor. Specifically, Odyssey Trust, which was the agent for Medmen, informed us that Medmen had in fact put into place a requirement that the shares had to be sold within 30 days.
Okay, and even if they did,
yes.
Are there any damages to your clients as a result? I mean, from the record we see, there hasn't been any evidence that your clients were damaged by allegedly having to re-legend those after they lifted it. So help me understand where there's damage, even if everything that you've said factually up to this point is true. What's the harm?
Sure. We lost the ability to exercise Section 9.01 II of the Asset Purchase Agreement, which permitted us to terminate the transaction in the event they were not able to satisfy the conditions of the contract. Section 2.03 AII, Section 4.04, Section 7.03 CII all stated that once we received the shares, they would be free of an encumbrance. They knew at the time in which we signed the contract on September 29, 2018, that there would be a requirement in place that required us to return the shares once the restrictive legend was removed if they were not eminently sold. That is opposite.
Return the shares for what?
Excuse me?
Return the shares and what?
Return the shares for re-legending, Your Honor.
Okay, so after that 30-day period, you'd get back shares that had the same legend as before the 30-day period, right?
That is correct.
And that's the legend that you just told us everyone acknowledges we knew would be on there.
That is correct.
Okay.
And to your particular point,
I don't have a point.
right,
just
no,
wanted to make sure.
but I understand the logic train that you're drawing because this is what Medmen's trying to say is.
Don't assume I'm logical.
Fair enough, Your Honor. But then what's the harm? The harm is during that period of time when we have to return the shares for re-legending, the shares are locked out from trading.
Did you return the shares for re-legending?
Yes, we did, Your Honor.
Okay.
Dustin Johnson, who was the manager of Whitestar
Represent Dustin
Solutions.
Johnson?
Mr. Johnson is a manager of Whitestar
You
Solutions.
represent Mr. Johnson.
In this particular case, Your Honor, I represent him in his context as manager of Whitestar Solutions LLC.
Is he bound by whatever we decide today?
So is he bound by whatever he decides
Are the
today?
individual members who, because obviously the shares were supposed to go to Whitestar, and then at your client's request, they went to members, or at least did all of them go to members, or did some of the shares end up actually going to Whitestar?
Sure. There's two components to that. One, it wasn't our request that the shares
Okay,
went to the
did
members.
any of the shares go to Whitestar?
Yes, they did, Your
Okay,
Honor.
so as a corporate entity, Whitestar got some of the shares, but then they were dispersed to some of the members as well, correct?
That is correct, Your
Okay,
Honor.
so are the members bound by our decision today?
Are the members bound by your decision today? I honestly, as I sit here today, Your Honor, I don't know the answer to that question because that issue has never come up. It wasn't argued below.
So why are you telling us what happened with Mr. Johnson? Doesn't he need to sue on his own behalf?
Because you specifically asked if any of the shares had tried to have the legend removed, and that was an example in which the shares.
But shouldn't we only care about the shares that Whitestar had? You raised the issue in your briefs that you don't have standing to pursue this claim. So I'm wondering, why are we here?
Your Honor, we don't raise the issue in terms of standing. Medmen raised the issue in terms of standing and suggesting a Whitestar
Well, and
solution.
you agreed with them.
No, we did not agree with that. We agreed that Whitestar does have standing, and Judge Martin, in fact, did find that standing existed as part of his summary judgment briefing analysis. That Whitestar did, in fact, suffer a particularized harm because it lost its right to exercise the termination right under 9.01 II.
So did Whitestar re-legend their shares? I mean, if what you've just told us is that everything here is limited to just Whitestar.
Sure.
Okay, that Dustin Johnson's not bound by this, that you're only representing him in his professional capacity. So if it's just Whitestar, did Whitestar have their issued stock re-legend? Did they lift the legend, Whitestar, your client?
The short answer is no. The longer answer is because of the way it was tranched. So tranche one, there were closing shares issued at the time of closing. There were tranche two shares in which certain shares were released post-closing, and there were tranche three shares, the earn-out shares.
Did any of those shares get re-legend? Did the legends get lifted from any of the shares that your client had?
Yes, they did.
Okay, did they try to re-legend any of the shares that Whitestar had?
No, they did not.
Okay, so why do we care if you didn't have them re-legend? What are Whitestar's damages?
At the time in which Whitestar got the second tranche of shares, the requirement the shares had been to be reapplied for the legend had been eliminated in April of 2019. So April 17, 2019, that's the date when Medmen signed the paperwork that eliminated the requirement that the shares had to be returned if they were not eminently sold. So that is the timeline in terms of why Whitestar did not have to send back their shares for reapplication legend because the requirement had already been removed.
So remind me what your damages are
The
then.
damages, again, are we lost the right to exercise our termination right. Mr. Johnson, who negotiated the deal, who was the manager of Whitestar, was unequivocal in telling Judge Viola at the evidentiary hearing and then subsequently at deposition that had we been told that there was any requirement that the legends had to be returned, if not sold within a period of time, we would not have done the transaction. That's the harm. As a consequence of us not exercising that right, we lost all of the membership shares that were transferred to Medmen. The material terms and condition of the contract, as Mr. Johnson testified, was the freedom that once those legends was removed, that we could time the market. We weren't able to time the market because they had put this restriction in place. that says-
Whitestar wasn't, or the members weren't?
Well, Your Honor, Whitestar wasn't,
But they never tried.
but they never tried because they,
Isn't that very speculative? I mean, did you present evidence in the record below as to we would have sold it on this date if we could, and that would have resulted in damages of this amount on the price, but we couldn't sell it? I mean, how, just the
Sure.
the naked allegation, we would have timed the market
Sure.
and got a better deal, seems entirely speculative, and our cases say over and over again, speculative damages aren't sufficient to defeat summary judgment.
except we're not asking for monetary damages as a result of the inability to time the market. The harm is the loss of our contractual right to terminate the agreement. That's what we keep missing. That's the harm that belongs specifically to Whitestar. They didn't belong to the members. The shares went to the members respectfully because Medmen made a mistake.
The reason I brought it up is you
Right.
said you lost the ability to time the market. So
Well-
your only argument on damages is the termination. That's all you're relying on.
The loss of the termination right that we would have exercised had we been told that Medmen put that in place. As a consequence of that, we lost the assets that we transferred to Medmen, which were the shares in Omaha Management Services LLC.
Okay,
which-
but you're talking about rescission, and because we're not talking about breach anymore, because that's where you're going here.
Correct.
And breach would be compensable anyway.
Sure.
But your terms, Whitestar's terms were to get a certain percentage or a certain set of stock that would be encumbered, you acknowledge, it would bear a legend, correct?
Correct.
All right. So Whitestar knew that this legend was going to apply.
Correct.
Okay, and that it would at least have to go through some process to free that up because these were not registered securities with
Correct.
the SEC. Okay, so Medmen already knew that this stock was delicate and its ability to sell it would be delicate and was tied to SEC regulations. Would you agree with that?
There's a lot to parse out there.
I
do not-
believe I asked
Sure.
a yes or no question.
Well, respectfully, Your Honor, I can't answer the yes or no, because the latter part is, you mentioned to say delicate. We don't agree that the term delicate, or these stock shares were delicate. There wasn't anything delicate about this, because there's no requirement under 904 that imposes a requirement that says once the legends are removed, the shares have to be returned for reledging. It is an accurate statement that in order for us to remove the restrictive legend, we have to exercise one of the exceptions. One of the exceptions is CFR 230.904. The only exception under that, which is commonly referred to as 904, is it has to be an offshore sale. There is no requirement in the express language of that CFR stating that the shares, if not sold by a date certain, had to be returned. There is no statute that states that. You have been cited no case that states that. So Medmen is asking you to adopt a requirement that is not found in the four corners of that CFR statute or any other court in this country.
So counsel, is that, you removed that 30-day legend. Has that ever been enforced against either your client or any of its members?
Yes, it was. It specifically was.
So Medmen said, you must do this within 30 days and get this back to us within 30 days.
Yes. And specifically, it's specifically found.
Where is that in the record?
Sure.
Can you give me chapter and verse on that?
Absolutely. If you look at Exhibit 40, which was admitted at the injunction hearing in front of Judge Viola, if you look at Statement of Fact 55 of Medmen, if you look at the Joint Pretrial Statement 24, in all three of those locations, it was stipulated and acknowledged that Odyssey told us and informed us that the shares had to be sold within 30 days. That was an instruction that
Okay,
came.
that wasn't the
That's-
question he asked.
That-
He asked, did any of these shares actually have the legend reimposed, subject, as Odyssey instructed you they had to?
Yes, Mr. Johnson.
Where is that?
Mr. Johnson returned his shares for reapplication of the legend.
But he's
after-
not bound by this. We've just determined that anything that Mr. Johnson did, he's not bound by this decision. You're not representing him in his individual capacity. He got these shares individually. So that's why I think I asked a question 7 minutes back. Did your client ever have to relegend their shares? And you said it doesn't matter because we're talking about rescission.
Sure.
So,
Your Honor, I apologize if I misunderstood the
no,
question.
and I may have asked it poorly,
Sure.
but I think you understand what we're trying to get to is we
Sure.
have to focus on on Whitestar.
Sure.
And you're focusing us on the fact that your damages are that you couldn't get out of the contract because you didn't know at the time that what you call a further restriction was going to be on this legend.
Correct.
So, did Whitestar ever have to relegend? And
So again, I want to try to make sure I parse it out so I can
Yeah.
understand. I misunderstood your original question, Your Honor. I apologize.
no, it's okay.
Says, I thought you were asking if Your Honor makes a decision, the other members are bound by it. That was a little bit different in terms of what I understood versus what I thought Your Honors were
Okay.
asking in terms of Mr. Johnson. Was Mr. Johnson bound to follow that? Yes. And the reason why he was bound to follow that is he was bound to comply with all the terms and conditions
Right.
that Medmen put in place.
But I guess my question was, when we're done, can Mr. Johnson sue Medmen again for just the fact scenario you
No,
laid out?
he cannot. No, if that's the specific question you're asking, he
Yeah,
cannot.
that was the specific
In
question,
this-
is the conclusions we draw in this decision going to bind Mr. Johnson against having to come back, getting
Sure.
a second bite at the apple?
Sure. I would tweak it a little bit and frame it a little bit differently because I don't think it's so much as a second bite of the apple, and I understand what Your Honor is saying.
Is
I
there
think-
any preclusion in our decision about that Medmen did or didn't violate this contract?
The answer to that question is no, but the bigger issue is Mr. Johnson was not an actual, well, that's not actually a correct statement because he was one of the signatories to the asset purchase agreement. The other members
But
that
in
was-
his
In his
capacity.
official
as
capacity.
not a-
No, he actually signed it in his individual capacity as well. He is actually one of the signatories in his individual capacity as well.
But you only represent him in his professional.
That is correct. Only Whitestar Solutions is the party who did it. And the reason why, in that particular case, is because Whitestar Solutions is the one who owned the membership interest that was transferred to the Medmen. But to bring it back full circle to what Your Honor is saying, because the members were not actual parties to the asset purchase agreement, we acknowledge that the members cannot sue Medmen because this restriction was in place, because the members did not have any contractual rights. The party with the contractual rights is Whitestar. They're the ones who own the assets. They're the ones who had the termination right. They're the ones who negotiated the deal. They're the ones who was represented that these shares would not have an obligation for reapplication of legend once the initial legend was removed. That's why at the end of the day, I'm going to end and reserve the last few minutes for rebuttal on where I started. That's why Whitestar has damages, because all these contractual rights, all these issues that we are talking about, the actual harm, it's Whitestar who was the party. It's Whitestar that conveyed the assets. It's Whitestar that relied on the representations. And but for those representations, it would not have transferred the assets. So in terms of rescission, absolutely, Your Honor is correct. We are seeking rescission. But as part of that rescission, we are entitled to rescissionary damages as well. And the way in which you book rescissionary damages is the value of the assets that was conveyed at the time in which the contract was fraudulently induced and entered into. So the analysis in terms of did you miss the ability to time the market, what was the share price versus the non-share price, that's irrelevant because that's not how we define rescissionary damages. We define rescissionary damages as what was the value of the asset at time in which it was conveyed. And if we unwind this transaction, what do we have to provide you in order to compensate you for that circumstances? In this case, we ask that the transaction be unwind, meaning the shares be returned to us, or alternatively, that we get a value of the assets that were conveyed as a result of the fraud, which is our rescissionary damages. That's how Whitestar was damaged. I'd like to reserve the last little minute and a half or so for rebuttal. Thank you, Your Honors.
Almost 2 full minutes.
Close enough.
Good morning, Your Honors. May it please the Court, Steve Jerome, Jennifer Catero, and James Florentine of Snell and Wilmer on behalf of Applee Medmen. I would like to just real quickly address the issue raised at the end there by Mr. Lopez, and that is the rescissionary damages. There was a pending motion for summary judgment barring count. An aspect of the motion for summary judgment was seeking summary judgment that those damages, rescission was not available under Delaware law. The trial court didn't have to get to that because it granted the motion on other grounds. So if this court reversed, that issue would then have to be determined. And so I think it's incorrect to say that that's what they're entitled to. There was a pending motion for summary judgment on the very issue that wasn't decided. With respect to the shares and the three tranches, there was the closing shares, there was the second tranche, and there was the earnout shares. The litigation has always surrounded the closing shares. And none of the closing shares were issued to Whitestar. And I find it disingenuous to continuously hear it was because of a press release that it required these shares to be issued directly to the Whitestar members. A press release specifically and directly, undisputably approved by Whitestar before it was issued. So to sit there and say that caused a problem and it's our fault when they signed off on it is, again, disingenuous. But I think here, the court in its questions has really kind of hit on the issues. There's both the fraudulent inducement claim and the breach of contract claim have three overlapping elements that are completely missing of any factual support by the appellant. And that is, was the alleged reledging requirement, did it exist? Was it applied to them? And did it cause them any harm? And Your Honors teed up, in Appellee's appendix tabs 6 and 7 are the emails that were referenced a few moments ago. And that is, they specifically state in October, so after the APA is signed, but still within this window that they can Whitestar can terminate the agreement, that you may remove the legend as part of a sale. That's what 904 of Regulation S, it's a sale exemption. It's not a wash off my restriction and give me unrestricted securities rule. I mean, if you think about it, if the regulatory scheme, it's so important under the 33 Act to require unregistered securities to have this restrictive legend that could be removed by simply filing a piece of paper that says, I may sell these in the next 100 years, that would essentially defeat the whole purpose of the restriction. And if you review Lisa Scotland's testimony, she walks through this process in great detail and explains how it works. These letters of representation are the protection necessary for Odyssey and Medmen they're representing that they're complying with federal securities laws. And so if the regulators ever come to us and say this was improper, we turn and say they represented and warranted it, that they were complying with the law. 904, they haven't cited.
Yeah, but their argument is, and there are some facts that they point to suggest that it's true, that they were told that they could get rid of these. And I think you're correct that that's not accurate, but don't we still have to rely on whether they were told that or not?
Well, again, I disagree. I mean, the email evidence is very clear that they were told they could remove it as part of a sale. I mean, that's tabs 6 and 7 in our appendix. It says you may remove it by a sale. There's a follow, and there's an acknowledgement by Whitestar representative, understood. And in fact, if you go to tab 4, which is the declaration by Mr. Johnson, I believe, he acknowledges in paragraph 35, we understood that we had to sell the shares in Canada as a bona fide transaction and not some scheme to wash off the legend. That's their declaration. They understood that. And during this transaction, on securities, they were represented by DLA Piper, one of the top 5 largest law firms in the world. And to sit there and say they didn't know, and what they're really complaining about is our forms said you can't violate U.S. securities laws. But here's the kicker. They did. If you look at the chart in our brief, which is at starts on page 16, goes on to 17 and 18, of the closing shares, only Mr. Johnson voluntarily, he sold in February, he removed the legend from all his shares, he sold 1,000 shares, and then voluntarily returned them to have there is no evidence that anyone sent him an email, a text, required him to do this. And then a few months later, removed them, and they've all remained indefinitely. This alleged reledging requirement, There is no evidence in the record that it was ever applied to any of the closing shares. And Mr. Lopez says, well, that's because they changed their instruction letters in April of 19. Not true. If you turn to tab 23, which is the collection of the various forms submitted by the closing share recipients and their brokers. For example, Mr. McCleary, his form is dated November 19th, 2019. Same language is in there, that you have to sell, because you're representing to Medmen and the transfer agent Odyssey that you're complying with U.S. securities laws. So you get the issue of, one, to the extent it exists and this problem was created, it was created by their own misapplication and misuse of a sale exemption. I mean, Mr. McCleary, and I'll talk a little bit more again, it's interesting, when he was deposed in May of 21, he testified that he had never even tried to sell his shares. Yet 18 months before, he submits a declaration saying this is part of a sale and removed the restriction from his shares. That's, one, bad faith vis-a-vis us, but to sit there and say that there was no contemplation in his mind of a sale at that time by his own deposition testimony. So they were using it to wash off. And that's not appropriate as set forth by Ms. Scotland's testimony. It's not appropriate as set by our expert's testimony and his expert reports. You cannot use it to evade the restriction. You remove it when you can sell. And this whole timing the market argument, as Ms. Scotland testified, they can remove that restriction within an hour.
Can you touch on, and we spent a lot of time on this with your colleague, I'm confused by who's here. And
we are as well.
standing and whether this is a valid case or controversy. So help me out there.
Your Honor, the people that had that they claim this 904 restriction, relegitiming requirement was applied to was not the appellant, the plaintiff. It was applied to the share recipients, the members of Whitestar. They received the closing shares. So if the share went up $300 to $300, they got all the money. If the share went down to the stock price went down to a penny, they suffered the loss. We raised this issue, and to me, whether it's standing or damages, the harm in the stock price issue or this harm caused by the alleged relegitiming requirement would solely impact the owner of the shares, which as to the closing shares, was what the litigation is about, that is the individual members of Whitestar, not Whitestar.
But your colleague just told us, and I thought pretty persuasively, that Whitestar's damages, not the individual members, is the ability the misrepresentation or alleged misrepresentation kept them from backing out of the contract. And so their damages is basically the fact they didn't get the stuff they gave you for the contract, their consideration back. So isn't that enough to preserve standing here?
It could be enough to preserve standing, and I suspect that's why Judge Martin found that they did have standing, but then found that they hadn't established damages. Because under Delaware law, to establish rescission, monetary damages have to be uncalculable and unprovidable, and here they are, because this is a publicly traded company. There is no evidence that any share recipient tried to sell on a specific date and was barred, was able to sell later at a different date for a lower price. There's no evidence in the record that anyone ever actually tried. I mean, you have Mr. McCreary who says, I never tried to sell my shares. And you have the representative of Fijian Investments saying, yeah, I sold mine, it was no problem. So there's no evidence of any pecuniary harm here. And I think that's important because the analogy I used in front of Judge Martin is, let's say you buy a car that has a lien on the title and you pay it off. And the bank, told you that they were going to remove that notation of lien within a week. Takes them 6 months. Did you suffer any harm by that? Maybe. If you tried to sell and were prevented from selling and then were able to sell later at a lower price, yeah, you have damages. But if you were happy with your guard, you never tried to sell it and then the notation came off, how are you harmed? Other than your mental anguish, you have no harm here. And that's, again, what they're trying to basically conflate the allegation of breach and the allegation of damages to create this whole, we weren't able to terminate the agreement. Well, one, they would also, if you go to that, have to say that they reasonably relied that they wouldn't have to comply with 904 after being told in writing that they would have to comply with 904 while being represented by DLA Piper as their securities counsel. So that's where the elements keep, whether you say that there was a misrepresentation, and even if you can say that they reasonably relied on it, you still have the issue of, did it approximately cause pecuniary damage?
But your analogy with the car, not to beat a dead car, is, I think of it more as if you sell me a car and you say, here's clean title to the car, and I go, or here's the title, there's a lien on it, but I'm going to get that lien taken off.
Right.
And I go, great, and I give you the money, and then 30 days later, the lien's not taken off. Isn't that closer to the analogy that they're providing?
Sure, but let's go with that analogy. Are you harmed by that?
Well, yes, because I've got a car that's got a lien on it, and I can't sell it as easily.
But if the lien is then removed 30 more days after that, are you harmed by that? The answer is, if you never had to make any payments, it didn't impact your credit,
and your argument would be, I'd have to show you that I tried to sell it, and I would have had a great buyer that would have...
Because you have a
given me
causation
great
and harm. You can't just say that, and it has to be material. You can't just say, I would have never done the deal had I known, because you basically take away the whole concepts of cure and mitigation. I mean, they're just basically saying, I wouldn't have known. And let's be honest. The only reason we're
I hope
here...
you've been honest the entire time.
No,
So.
I have been honest the entire time, Your Honor. Apologize for the figure of speech. The only reason we're here is because the Medmen share price significantly decreased post-closing. If this had become Apple or Amazon and the share price went up to $300-400 a share...
Yeah, but that's every case that
Right,
ever
so this
appears
is-
in any court. Things go
Right.
bad, and that's when we have to get involved.
Because there is no evidence that not every single one of the share recipients, I mean, Mr. Johnson sold shares, they received the shares in December, closed in December. He sold shares in February. There's no evidence he couldn't have sold 100% of his shares that day. There's no evidence that not every single one of the closing share recipients could have sold 100% of their shares that day. I mean, it is undisputed that since Medmen went public in spring of 2018 and between a date in September 21 that the disclosure information was produced, Medmen's transferred approximately 750 legend removals pertaining to over 500 million shares that were then sold on the market. To say that this $4 million worth of shares couldn't have been sold is ridiculous. There's no evidence. It's a speculative harm for which there is no evidence that they actually, some of the people sold had no issue. Some have never tried to sell. So how can you be harmed by something that's never actually impacted you? Never actually applied to you? I mean, there's no evidence that, as to Whitestar shares, this reledging issue was never applied. Because the litigation has been about the closing shares, and they didn't receive any of the closing shares. There is no evidence in the record that Whitestar submitted a declaration and had its legend removed in the first place, or that was required to relegend. There is nothing in the record to support that at all. And so from our perspective, this is a case where, again, you don't have any damages. So it only arose because they inappropriately tried to use 904, and it was never, in fact, applied to them. No, as Ms. Scotland testified, there's no enforcement mechanism, nothing done by, there's no evidence, there's no email from Medmen saying, hey, you need to relegend that. No email from Odyssey saying, you need to relegend that. There's no even testimony that alleging someone called them and said, you haven't done this, you need to do it. And, again, the chart, I mean, some of these people have had unrestricted securities now for years. And that's undisputed. And in case Mr. Lopez says, well, how do we know that that chart is accurate? The actual transactional documents from Odyssey are in the appendix. It's the DRS statements and the Odyssey transfer journal. So if you can tie out all those data points on that chart from those documents. So it is absolutely clear to me that what we have is speculative harm at best to closing share recipients, none of whom are here. None of whom, and in fact, in a twist of irony, they cite in their brief at the time, COO of Medmen, and saying this establishes she was a share recipient. She was one of the Whitestar members. She clearly knew that she could have sued or challenged this, but it boils down to they can't use 904 to wash off. Mr. Johnson admitted it. The expert acknowledged it. The forms say that. Odyssey says that has to be part of a sale. And if you think about it, if you can only remove the...
Counsel, if we, and let's say that we agree that you can't wash off, right? I don't think counsel would disagree with that. Where's the 30-day requirement? And in our record do we find that Medmen is the party that is the source of the 30-day requirement?
That's a great question. So the source of the 30-day requirement was Jennifer Garcia at FineMark, one of the Whitestar members' broker. And she informed, and I disagree with Mr. Lopez on the stipulated facts, she informed the Whitestar members that there was this 30-day requirement. The Whitestar members contacted Medmen. Medmen, and almost proving the theory of no good deed goes unpunished, assumed they were right and ran around like a headless chicken trying to solve a problem that didn't exist.
Okay, so the representation that the re-legending requirement referred to a 30-day re-legending imposition, okay, which is what we're talking about here.
Right.
Okay? That has its origin from
Jennifer
Whitestar's,
Garcia at FineMark.
Whitestar's broker.
Right. And all you have to do is look at the forms that are in tab 23 that were executed by the Whitestar members, and not one of them says return in 30 days. It's not there. So there is no 30-day requirement. Did Medmen run around trying to solve a problem that they erroneously thought exists? Absolutely. But that's not a sign of someone who's trying to pull a fast one. It's someone who cares about their investors and then trying to solve a problem. And they went back to Odyssey, and that's where, when Mr. Lopez talks about the injunction hearing, it wasn't until after the injunction hearing that, in confirming through discovery, that Odyssey comes back and says, you never had a 30-day requirement. We were mistaken. It's not in your documents. So there is no 30-day requirement. There was no 30-day requirement, and that's why their argument morphed to imminently is de facto 30.
Wouldn't the argument be the same even if it had originated from you all?
Yes, because it's not, again, because what they would point to is where there's nothing specific in the regulation that
Yeah, I can't
requires.
figure out why 30 days matters if and I'll hear from your colleague, if everyone agrees that you should only really be able to take this off in connection with an actual sale. So taking it off and then having the sale fall through means it goes back on. Is that a good shorthand way of summarizing it?
Yes.
Okay. So I don't know why it matters if it's a 30-day, 2-day, 6-month, or just you got to get it done. Why does that matter?
Well, and what they will tell you is that we are creating out of whole cloth the re-legending requirement. And as testified to Ms. Scotland, technically for compliance in 904, you're not supposed to remove it until the sale's actually concurrently concluding at escrow. But to facilitate efficient securities transactions, what the transfer agents and the members of the Canadian Stock Exchange do is you represent this is part of a sale.
That you have a buyer.
You have
you're
a
gonna
buyer
be
that's
ready
going
to
to
go.
happen. And so they remove it.
Right.
It then transfers to the broker's account in unrestricted form, and then they can sell it on the exchange. But if it turns out you don't have a sale, it was improper to remove it in the first place, and you can't then say, well, I guess
Because that
means
looks
I get...
like a wash.
Yeah, and that's the wash-off. You can't use it. And we know that's what they did because Mr. McGreary testified 18 months after he certified to Medmen and Odyssey that he had a pending sale that he'd never even tried to sell. So we know that's exactly what they're doing, and yet they're complaining that our paperwork requires them not to violate the law, and then it's their enforcement issue, not ours.
But the follow-up to my question is, so I think 30 days, and I'm not a securities lawyer expert by any standard, the 30 days seems to me to be a red herring. Isn't it really just whether there's a re-legending requirement that is the issue? So who cares who said you have to get it done in 30 days? If you guys were wrong about telling them they had to re-legend, isn't he right?
I don't think he would be right in the sense if we told him that they could use 904 not in connection with a sale. We never said that. The emails say you may use this sale exemption in connection with a sale of your securities to remove the legend. And so they're saying what you were really saying is we could pretend to have a sale and wash off the restricted legend, and that's not supported. And their own testimony by their principal says they understood they couldn't do that. That's his declaration.
It's a fine distinction, isn't it?
It's a fine distinction, but it's securities laws, and it's an important distinction, is that because it's their representation, if an enforcement action is ever initiated, it's their violation of the law that's at issue, not ours, because they told us they would comply with the law. That's in there to protect us in the event they don't comply with the law. We can say, we told them they have to do it. They have to comply with the law. Thank you.
Thank you very much, counsel. You've got a minute 52.
Thank you, Your Honor. Let me start right there on 904. There is no language in the CFR that states that you have to have an identified sale as a condition to remove the restrictive legend. And in fact, it is a factual impossibility that you could ever accomplish that in this case because you are selling shares on the stock exchange.
But you do agree that you cannot remove the legend for the purpose of washing the shares.
Well, let's be really clear in terms of what washing the shares means. Washing the shares means taking the shares, selling them outside the country, and then selling them back inside the country. There's two ways in which you can remove this restriction. There's Rule 904, but there's also a one-year holding period. We could have held on to the shares for 1 year and then sell them in the States. But the way in which you get around that 1 year holding period is you can sell it outside offshore. And what the wash-off rule says is you cannot sell the shares offshore and then take those same shares and give it back to you and sell them in the States as the way to get around the 1 year rule. That's the distinction that counsel is not arguing. But in terms of 904 itself, you can never, when you sell shares on a stock exchange, tell me who you're going to share it to, what the share price is going to be, when they're going to be sold, because this is not selling real estate where you have a contracted buyer and a date closing. So that is not correct. Second of all, the analogy that counsel is using regarding the lien doesn't apply. The better analogy is I give you my 1967 Camaro for your Ferrari. And then it turns out the Ferrari that you represented is liened up and you don't have a free title Ferrari. What's the harm? The harm is rescissionary damages. I have the right to rescind the transaction to get back my Camaro. I'm not limited to the benefit of the bargain damages. That's what's being missed here. We were asking for rescissionary damages. Thank you, Your Honor.
Thank you, counsel. Thanks both sides for your arguments and your briefs. We appreciate it. We'll take this matter under advisement and issue a written decision in due course.